Jillian Golombowski versus M&D Concrete. This matter was set for, well, there was a bench trial that was set in October. There was a motion to withdraw that was granted on that day, and a judgment by default was issued against M&D Concrete. Subsequent to that, Mr. Betts filed this motion. And there have been responses by both Mr. Harris and Mr. Sataria. Mr. Betts, go ahead. It's your motion. Go ahead.
Thank you, Your Honor. It is true that Mr. Sudaraya made an oral motion at the time of trial to withdraw, which the court granted, but it was never followed up with any sort of written order. So since the court speaks through its written orders, he's still in the case, as is Mr. Harris.
Actually, no, he's not. I wrote motion to withdraw granted right on the file. So that is my written order.
All right. As to Mr. Harris, he filed, let me back up a little bit. I did not receive anything in writing from Mr. Sudaraya, so I don't really know what his position is. As to Mr. Harris, he did file a response. He sent me an email, a copy of it. He sent a copy of it to me by regular mail. And all he seems to say, he doesn't really dispute anything that's in my client's motion. All he says is, I prepared a stipulated order to withdraw or to have Mr. Sudaraya substitute, but Mr. Sudaraya never filed it. So,
and I think Mr. Sudaraya agrees that it was never filed. Is that correct, Mr. Sudaraya?
It appears that way, Judge.
Was that just an error?
I believe so. I was under the impression that it was filed, but based on the register of actions, it looks like it was never entered. So I can only use. And Judge, I did file a response.
I saw it.
I did attach a proof of mailing. I did mail it to Mr. Betts' office at 175 2nd Street. So I'm not sure why he doesn't have it.
Okay.
Well,
go ahead, Mr. Betts.
Right from the beginning of the case, all the defendant has ever tried to do here is to stall and to sandbag and to throw barriers in the way of my client. The defendant filed an answer to the complaint, or Mr. Sudaraya did, alleging all sorts of crazy defenses as far as release and fraud and all that stuff. And of course, we filed a discovery request saying to the defendant, okay, flesh this stuff out. I mean, do you really have a defense? And of course, they never answered one interrogatory. They never produced any documents. They didn't show up at the one pretrial conference that I know of for sure. They didn't show up for trial. And to put the frosting on the cake, at the last minute, the defendant goes out and files a new LLC with a very similar name, looking like his whole goal here is fraud, to try to defraud my client. As I say, I filed a 33-paragraph motion providing the court the chronology of everything that's happened here. All the court has to decide is that under that cited statute 600.2591, that the defendant filed frivolous defenses. And of course, I don't know what else you could say here, because the defendant has never provided anything other than his attorney's legal conclusions.
So you're asking for $10,000 in legal fees against M&D Concrete?
And the two attorneys, Judge.
Okay.
Under the statute.
Okay. Okay. Let's start with Mr. Satara. Go ahead. You've already, actually, I'm going to rule that Mr. Harris is not part of this, that there was an error in filing as an officer of the court. Mr. Satara has made that representation to the court that Mr. Harris should have been let out, that when Mr. Satara filed the answer, Mr. Harris has never done anything since that moment. Mr. Harris has said that he filed for the substitution. Mr. Satara thought that it was filed with the court. The only documents that we had moving forward was filed by Mr. Satara and nothing by Mr. Harris. And as an officer of the court, Mr. Satara has made those representations, and I'm going to deny any motion for attorney fees against Mr. Harris. So Mr.
Thank you,
Harris,
Judge.
you are free to go.
Thank you, Judge.
You're welcome. Now, Mr. Cetera, go ahead and respond.
Judge, I'm going to trust that the court has read my
Well,
response.
and I have, but let me just say, this is what I'm looking at. I just want you to talk about, I mean, obviously you're not representing M&D. And so they're not here. There's no one representing M&D. And so it is probably a default against them for the requests of the $10,000 in attorney fees. So the only thing I want you to address, because you don't represent M&D, is the issue of why you are not liable for any attorney fees.
Judge, this was a case where, if the court recalls, I withdrew before trial began. I filed an answer as I was representing M&D Concrete LLC at one point in time. M&D Concrete asked me to cease representation. I made the court aware of that.
Right.
I wasn't permission or authority to even respond to the.
I guess, Mr. Cetera, let me stop you for a second. Mr. Betts, what did Mr. Cetera do that rises? Because he represented them literally in my records through a couple of hearings. It was adjourned for discovery. What happened when I adjourned it back in February for discovery?
We filed discovery requests, and that's part of the problem in this case, that the defendant never responded.
Right. And how do you assess, and Mr. Cetera, as a breakdown, what happened with your client?
My client simply asked me to stop representing M&D as they didn't have any funds. The company was insolvent. He represented to me he was in the process of bankrupting M&D Concrete LLC. He was the sole owner of that entity. The entity didn't hold any assets whatsoever. So he asked me to simply withdraw from the case, Judge. And as a penalty for not responding to the discovery request, the court granted an order deeming the request for admissions granted.
Right. I understand that. Mr. Betts, I'm trying to figure out how you think you can get attorney fees against Mr. Cetera. What did he do? I'll grant you that M&D Concrete didn't do what they were supposed to do, or didn't cooperate with their attorneys, or told them that they're not doing anything. But what did this counsel do that rises to the level of having attorney fees granted against him? So much so that he withdrew at the bench trial and you got a default judgment.
Okay, Your Honor, if we look at that statute 600.2591 that I have cited in the motion, all you have to do is make a finding that Mr. Sudaraya filed a frivolous defense. And if we look at the affirmative defenses that he filed crazy ones: release, accord and satisfaction, discharge, bad faith, failure of consideration, all of that stuff. And of course, when we filed the discovery request, we said, what do you have to support these allegations? They never responded. They never did anything. That was the time when Mr. Sudaraya should have said, okay, we don't have anything to support these defenses. We're going to withdraw them. But they never did withdraw them. In theory, they were still on the table at the time of trial. So all the court has to do
Cetera, any response to that?
Yes, Judge. I mean, this is absolutely ridiculous. There was no evidence proffered in front of the court as to any of my affirmative defenses, as to any of the allegations in the complaint, period. We can't assess whether these defenses were frivolous or not. My testimony to the court is they were absolutely not frivolous. I just wasn't given the opportunity, or didn't make it far enough in the case, to even proffer any sort of evidence. Mr. Betts is using this motion as some sort of a guise to amend the complaint, amend the judgment. I withdrew at the time of trial. Mr. Betts was given the opportunity to take a default judgment. He filed a default judgment for the full amount allowed, $25,000. He left the attorney fee section blank for some reason and put in $217 in costs. So at the time of taking the default judgments, he should have entered in some attorney's fees at that point in time. I don't know why I would be liable for anything at this point. M&D Concrete LLC, I get it, Judge, is the only party here that's not represented. And if the court feels that M&D Concrete LLC is liable for some sort of attorney's fees, I would simply ask that they be reasonable attorney fees, not simply an arbitrary amount of $10,000 for filing a complaint, a motion to deem request admitted, and filing a default judgment. It seems a little bit out.
Your request, that's, Mr. Butts, I do have some concern about that as you throw out a number of $10,000 with no documentation to back it up at all.
Well, Judge, if you make a finding that Mr. Sudaraya filed frivolous defenses, then I
Well,
guess.
I can stop you right now because I'm not going to make that finding. I'm going to deny your motion for attorney fees against Mr. Sudaraya. I will leave open the motion for attorney fees against the defendant M&D contract, but I want a more definite statement filed before I issue an amount.
Understood.
All right?
And Judge, just so we're clear, this is not a proceeding that's against the different entity, M&D Concrete and Snow Removal LLC.
This is M&D Concrete. I can't make a finding
Exactly.
against somebody else that's not part of this lawsuit.
Okay, Judge, I just wanted to clarify. Thank you.
All right. If you want to file something, Mr. Butts, I need a more definite statement on the attorney fees.
Understood. Thank you, Judge.
You're welcome. Calvary versus Miranda Bloodworth.
Hello, Your Honor. Deborah Winslow on behalf of the plaintiff.
Oh, and I guess we don't have,
We don't yet, but it does look like we reached an agreement with her, but we sent her a consent judgment back in end of October, it looks like, and she has not returned it. So at this point, I would request that a default judgment be entered, and I can.
well,
send that
not
in,
yet.
or-
You
okay.
can't. Not until 11 o'clock. I give everybody
Oh.
a half hour.
Okay, no problem.
So you got a half hour. Mr. Best, we only have one side of your case. We need the defendant, and Miss Lewis, same thing. We need the defendant in your case. So apparently, everybody just hang out for half hour. Oh, wait, I have Mr. Coots on,
Okay, thank you, Your
which
Honor.
is Miss Lewis's case. Good morning, Mr. Coots.
Morning, how are you?
Good. Valerie
Just froze up, Your Honor.
McLeod
Sorry, yes.
versus Rick Juarez and Roxanne Dilicky. Miss Lewis is here and Mr. Coots represent both defendants. You guys had an opportunity to talk to each other at all?
Yes, we have, Your Honor. And actually, Ms. Dulecki passed away about 2 weeks ago. She had stage 4 cancer. In any event, both attorneys have been talking. We just need some, I guess, deadlines. Mr. Juarez he's not in the right frame of mind to talk about all of this right now. So at this point, I will defer to the court as far as either adjourning this for a brief period of time, or just give us some dates to put some heat on the attorneys to move this on.
Can I give you a January 12th, an adjourned pretrial, the January the 12th at like 10:45?
That works for me.
Is that okay, Miss Lewis? I actually knew Miss Dulecki through the years from the court, and will you please extend to Mr. Juarez that I'm sorry for his loss?
I will. So that was Jane, and is the court going to send out notices or no?
They will.
Thank you.
They will. Thank you. Have a good day.
You too.